very pleased that all of you are able to be here. This is one in a series of programs that the League's sponsoring, and we call them Joe Columino. And we're pleased tonight to have as moderator Nick Haynes, who's executive producer for public affairs at KCPT Public Television. So welcome, Nick, and take it away.
Well, thank you very much. I even get applause. This is fabulous. It doesn't get any better than this. Should we be changing the way we select our judges, or should we just leave this whole thing alone? That's what we're talking about today. Or, could it be if we modify the selection of those folks, those men and women who are wearing those robes, that somehow we could actually have a better system of justice for us all? We want you to have some open minds and open hearts here today as we are going to engage in a spirited conversation with some leading voices of people who are very much engaged in the art of the law from many different sides and lots of nuances in between. Some of the voices you're going to hear, because this is an issue that has been playing out all session long in the Kansas legislature, in the corridors of our leadership in Topeka, and has been causing huge amounts of indigestion as well at the Kansas Judicial Center, where the Kansas Court of Appeals and the Kansas Supreme Court it resides. With us on my right here is Lynn Johnson, who has been around this himself. He's been part of that selection of Supreme Court justices in Kansas. He's chair of the Kansas Supreme Court Nominating Commission. He's a former chair of the Kansas Trial Lawyers Association. He is the principal shareholder and president of Schamberg Johnson law firm right here in Kansas City, where he specializes in complicated personal injury and wrongful death litigation. In fact, before moving on to our other panelists, I actually prefer, if I could be so bold, and change the normal way of doing things. Can I be so bold, ladies and gentlemen? Thank you very much for that. Give us your take, if you will, before we move on. Where did you come down on this issue, Lynn? Do we need a change?
Well, do you mind if I stand?
Please stand.
I like
let's
to
make sure
stand.
your microphone is working.
Well,
This is the way
either
they
that-
do it in the courtroom. Let's make sure your mic is on.
Okay. All right. Can you hear me?
Yes.
Is the mic on? Yes, it is. Well, I've had the honor of being one of, since the people of Kansas changed the Constitution to provide for a Supreme Court nominating commission, a nonpartisan commission, as it's called in the Constitution and in the resolution that resulted in the people of Kansas in the fall of 1958 by more than 60% deciding that the best way to select justices of the Supreme Court at that point was through a system that was non-political and non-partisan, as it's described. Since then, there have been 8 chair of the commission, and I started by saying I was honored to serve 2 terms as chair of the commission. For those of you who don't know, just brief nuts and bolts, prior to the fall of 1958, Supreme Court justices, we did not have a Court of Appeals at that time, were elected. And that was provided for in our Constitution that was adopted in Wyandotte in 1859. And there was a modification in 1899 that made it a little more clear. So judges were elected unless a judge resigned, justice I should say, resigned, and then a justice was appointed by the governor. And the governor could appoint anyone he wanted. And that resulted in what I'm sure all of you have heard about, the triple play in 1957 that resulted in a political coup, so to speak, by the former Governor Hall. And so the Senate and the House, and I've gone back and tried to do a little bit of research to see what the votes were in the Senate and the House, but I couldn't find it. But we do know that the House and the Senate in Kansas in 1957 passed a resolution for a constitutional amendment to provide for the Supreme Court nominating commission to be the commission that recommended to the governor 3 names for any position that became available on the Supreme Court. It had to have a 2/3 majority, so we know it had at least 2/3 of the members of the Senate and 2/3 of the members of the House. And at least according to the Topeka Capitol in my research, in the fall of 1958, I guess the second Tuesday of November of 1958, it got over 60% of the votes. Since then, it has functioned very, very well and non-politically and non-partisan. The chair is elected by all of the attorneys in Kansas, not just members of the Kansas Bar. 4 other seats from the 4 congressional districts, and if you go back to 58, we had 5 or maybe 6, anyway. 4 congressional seats, so within each congressional district, there is an election by all the lawyers in that district, not just members of the Kansas. Elected to a 4-year term. And then the governor appoints 4 lay people from the 4 congressional districts on staggered 4-year terms. I had the honor of being on the commission with lay people who had been appointed by Governor Finney, who's a Democrat. And as I progressed in my 8 years, by the time I finished, all 4 members had been appointed by Governor Graves. So I've had the opportunity to work with lay people appointed by Governor Finney and lay people appointed by Governor Graves. And I can tell you, without exception, those were not political appointments. By that I mean the people that were appointed by Governor Finney and by Governor Graves came to the commission to do what was envisioned back in 1958, to be nonpartisan and non-political, and to choose the very best from the 20 or 30 or however many candidates, attorneys, who had applied. The same is true of the attorneys. Non-political, non-partisan attorneys who decided as part of their giving back to the legal community, decided to run to be on the commission in each congressional district. And that's why I did it, to give back to the legal community by being the chair. I have yet to see anyone who talks about, quote, reform, end quote, point out any Supreme Court justice or any member of the Court of Appeals who should not be there. There's a problem or has been, there's simply nothing that anyone can point to that would indicate that this system hasn't worked. And I'll have a chance to talk a little bit more about this, but I can tell you that when I was chair and Dick Height followed me, Dick is a very fabulous, wonderful defense attorney in Wichita, and now Ann Burke, who's practices here in Johnson County. I can tell you from talking with them that it's the same, or at least it has been until recently, been the same, and that is that the people who are there working on that commission work hard. We spend a lot of time going through every candidate's resume and making phone calls and doing background work. For every candidate, we probably spend 8 or 9 or 10 or more hours before there's even an interview process. And during that process, the interview process, when we decide the 3 that should go to the governor, there is never, ever a discussion of whether a particular candidate is a Republican or a Democrat or a Martian or whatever. It is purely and simply merit selection at its best. And I would challenge anyone who wants to change this system to tell me of one single Supreme Court justice appointed by a variety of governors, or a Court of Appeals judge appointed by a variety of governors, is somehow some rogue, horrible person who shouldn't be there, who doesn't deserve to be there, who doesn't have the legal qualifications to be there, who doesn't have the intellectual capacity to be there, who doesn't want to do what Judge Arnoldberger wants to do and every other member of the court wants to do, and that is to do their job the very best way they can. So, the only complaint I've heard is that there's 5 lawyers and 4 lay people. 5 lawyers and 4 lay people. That's been held to be constitutional in a recent case in the 10th Circuit. And I kind of like Justice Six in his recent article, Justice Six, who should go to the Supreme Court, when he said, who better to determine the qualifications of attorneys who come before the commission than other attorneys? Kansas Medical Society, the Kansas Board of Healing Arts, which licenses doctors, is it made up of lay people? It's made up of doctors. Same thing for every other professional group. Now, it's a little different, I realize, in the Supreme Court, but the point is the same, as he points out. Who better? The other complaint is, well, what about these people that are on the nominating commission before the Supreme Court? How about people appearing before the Supreme Court, lawyers, in a system where there's elected justices, where I've had to give money? Who are they going to raise money from? They're going to raise money from the lawyers. I don't have to worry about that now, because I know when I'm in front of Judge Arnoldberger, I didn't give her any money, and my opponent didn't give her any money. She's going to be fair to both sides, and every judge that I appear in front of is the same. Sorry, I get a little worked up about this. Bottom line, in Kansas, I can't speak to Missouri, in Kansas, it works.
And that is one take, Councillor, that you will hear among 4 that we've assembled for you to hear in this forum compiled by the League of Women Voters for you to hear. That was Lynn Johnson. I want to introduce you to another take that you're going to hear on this issue about judges. Do we need to change the selection? Next is Professor Bill Eckhart. He teaches criminal law, administrative law, and evidence at the University of Missouri, Kansas City. He's a former military attorney who served as chief prosecutor during the My Lai massacre cases, the mass murder of between 347 and 504 unarmed civilians in South Vietnam in 1968 by US soldiers in the Army's 1st Battalion. Now, your experience is hugely broad, your knowledge is incredibly wide, and I have to tell you right now, I have no idea where you are going to come down on this issue, which is the most wonderful thing about this forum. We're going to have a lot of nuance here, but you have a tremendous experience in this whole area. You're teaching law at UMKC. Where do you come down on this, Professor Eckhart?
Nick, I would like to thank the League of Women Voters who, particularly with the snow, have gone over and above the call of duty to gather us here tonight, and I thank you. I'm the Missouri interloper. I think it appropriate for me to talk as I will about Missouri, and you can draw your conclusions if they apply by analogy, I guess is the best way to say that. I got involved in this in a strange sort of way because to be blunt, when you're a part of a group that has an vested interest in the outcome, to argue for reform is not good for business. And they were having a great deal of difficulty finding anybody who would argue for reform. So I said, well, I considered it part of a civic duty to present such issues and argue for them, and so I did that. And we worked pretty hard, and we came up with a brochure. We started this. I think you folks started in about 2005, whatever the thing, and we started about 2007 with a brochure like this, and it'd been out about an hour when my dean got 5 calls asking that I be fired. And I knew then that this was going to be quite different, and it has been. So let me, basically, the question is not politics, and it's not reform, it's accountability. Good old political science accountability and democracy. Those are the issues. And I want to say this, Missouri is proud because the Missouri contribution to the art of governing is the Missouri Plan, starting at about 1940, and we are proud of it. In my position, I guess my bottom line, you're entitled to it. I have fought like mad to reform that particular system, update it, I guess. Maybe if we don't use the word reform, just simply update it from 1940 for the reasons I'll talk about. And if that fails and I'm pushed, I believe in some sort of democratic processes so that the federal system is what I would have to fall back on. I'm adamantly opposed to elections. I don't know whether this has happened in Kansas, but in Missouri we've gone through session after session, we tried to reform. The bar will simply not even put one proposal forward, even to take the judge out of the selection process, which the American Judicature Society says is just not the way you do things. Will not even do that. And I'm afraid time's passed. I think if reform comes again in Missouri, we'd be lucky if we had the federal system. It will probably go to elections, which about 60 to 65% of the voting population would vote for. In the minority population, it'd be about 95% would vote for it, and it would pass overwhelmingly. And I don't think there's anything that we lawyers could do to stop it, and that grieves me. But let me be brief, and I'm going to be perhaps harsh a little bit. I train trial lawyers. I love trial lawyers. I'm a lawyer. My family's been a lawyer. My family has long legal tradition in Missouri, which we're darn proud of. But unfortunately, as far as this particular process, it's become elitist, undemocratic, and clubby. Run loosely and informally, unstructured, unaccountable, and dominated by special interest. That's the bottom line. Since we started our reform, we've had some success, for which I thank the bar and I thank the court. The first thing is our Chief Justice, right after we started this particular process, issued a report. We basically tackling the retention processes, admitting publicly it was broken and trying to do something about it. And we appreciate that, and I think we made some progress. That was followed the next year by another State of the Judiciary address, where about a third of it was taken up by the Chief Justice, and this time was trying to get more information about the courts. And the third one is the bar itself, in its election process, has done some things which we appreciate. But the problem is that currently there is no political branch that is directly politically accountable for selection of our judiciary, and I just think that's terrible public policy. The governor, who selects 3 people, and the bar selects 3, and the chief judge is the other one, so that's 7. So no one is directly accountable. The legislature is totally out of the processes, and even the governor has his hands tied behind his back. And I just don't think that ought to do it. Now, I don't know whether we've had our triple play, but for the past 20 years, only 2 Republicans have been on panels going to the governor. Every Democratic governor has been able to choose from 3 Democrats on each panel presented to him. Only 1 Republican was on each of 2 panels going to the sole Republican governor. In 2007, the Judiciary Commission sent 2 Democrats and an apparent Republican to the governor. The selected apparent Republican nominee was in the middle of a class, not on law review, held no senior partner experience, but voted with the chief judge 100% of the time on the Court of Appeals. When choosing a minority candidate at this particular time was extremely important. 2 comparative candidates in race and gender made the final cut, the final cut. One that was sent to the governor had the lowest bar rating of any appellate Supreme Court judge in the 2006 retention elections. The candidate not forwarded was the top of the class at MU in journalism, a Harvard Law graduate, a partner of a major law firm, had extensive trial and appellate experience, and a reputation for tight control of the courtroom. 2008, the Judicial Commission included only one Republican, and the one selected happened to be a Missouri Missouri Association of Trial Attorneys Board of Governors member. The short list sent to the not on the short list but not sent to the governor was a federal clerk, a law professor, and a law school dean. If that weren't bad enough, the public, while being denied information on who was on the list of nominees, the list of nominees was quietly circulated with certain law firms in St. Louis and Kansas City, prompting an unprecedented appearance by the Chief Justice in front of a legislative committee. When we started this, it's been interesting to me, we had certain goals that we wanted, and I've tried as we maneuvered around this to stick to those goals in some sort of form. And the first was that we desperately wanted a reform of the Missouri Plan. As you know, when we talk about court selection, we have elections, and there are some that are partisan, and there are about 7 states that do that. Nonpartisan elections, there are about 15. The next category are those that deal with appointment in some way. And there are 2 that have legislative appointment, and 15 have some sort of governmental appointments. And then there are 4 different branches, if we call them, of the Missouri Plan, which gives us a lot of maneuverability in what we call merit selection, which we care so much about. The Missouri Plan with legislative input, there's a Missouri Plan with gubernatorial input, there's a Missouri Plan with an alternative type of commission, and then we have what Kansas and Missouri has, is a Missouri Plan that basically is controlled by the bar. There's where we are. So what reform, and I'll close with this, what reform, what are the big pictures of reform that were we after? Number 1, simply updating the Missouri Plan. Number 2, we thought that basically the sunshine laws should apply. There should be certainly some standard procedure for when we meet, when they vote, some requirement of voting, some method, as the governors have complained about, of transferring information from the commission to the governor, because Governor Holden said the political process started all over again after the commission was through. Surely we can have some sort of procedures like that. We ought to have a procedure, in our view, where the judges should not select judges. I've had sort of a lot of fun in this as we've debated this. I just turn sometimes to my colleague and I say, well, I'm sure you would like Judge Rehnquist to select be involved in the selection of the next person on the court, because they know so much about this. The commission, of course, should be nonpartisan, but it should be politically accountable. We need lawyers. The lawyers ought to be on these commissions, folks. The question is political accountability. Whether the legislature puts them on there, the governor puts them on there, there are a whole bunch of ways to do that. But it desperately needs to be done. And if you believe in democracy, we don't farm out a branch of government, folks. If you believe in democracy, in Missouri, we think that the legislative branch should be included somehow in the process, either that or the executive. Somehow, somebody ought to be politically accountable. So the bottom line, let's reform the system. The laws are 70 years old. They need to be reformed. They're not bad, but they need reforming. And those of us who have been in the trenches have tried to do that. We're pretty bloody, but we've tried to do that. Thank you, Nick.
That's 2 takes on our question. Here's a third. We have an actual Kansas Court of Appeals judge with us, a real-life Court of Appeals judge. In fact, we have a 13th of the entire Kansas Court of Appeals. Karen Arnold Berger was born in Kansas City, Kansas, and graduated just down the road at Shawnee Mission North High School. She had been wielding her gavel on the bench of the Overland Park Municipal Court when Governor Mark Parkinson appointed her to the rarefied heights of the Kansas Court of Appeals in 2011. Now, just because you serve on the bench, I'm not going to assume what your position is. You may actually, Judge, want to see a major change. You may not like the people you're serving with and think it's a need for a change. Now, tell us your position on this question.
Well, my position in that of the
Let's use this one over here. I like this one far better. And it does work better. There we go.
My position in that of the Kansas Court of Appeals has been, as we testified before the legislature, that we feel that the current system is not broken. And unless we can see some real need for change, we think it's served us well. You know, Lynn has already gone through the history of how we got to this point in Kansas, but we had a system where an overreaching governor manipulated the system to appoint himself for his own personal gain. And although the professor has, I can't even begin to address a lot of the things the professor mentioned, I just don't think we've had perhaps the same experience that he's had in Missouri and Kansas. We've had a system that served us very well. It served us so well that in 35 years ago, when Kansas established the Kansas Court of Appeals, the legislature decided to adopt the same sort of selection system for the Court of Appeals that it had constitutionally mandated for the Kansas Supreme Court. And I think it's important to note, not only did the voters of the state of Kansas vote to change to a merit selection system through the Constitution, but they also constitutionally established the nominating commission. They felt it was important that this nominating commission be nonpartisan, that it have representation from lawyers throughout the state, and that that was the way to make it truly merit-based. I have not heard, as Lynn has mentioned, I have not heard of rogue judges out there that have presented a problem. In fact, when Senator King was on the floor of the Senate introducing legislation for a constitutional amendment, he was asked and specifically responded that he has heard of no problems with current judges on the court in any way, shape, or form, not one complaint. So I am concerned, and I think voters need to ask exactly what are we trying to fix here? Are we, and certainly, I guess to borrow from the medical profession, if it's not broke, don't fix it, and if it's not broke, certainly don't break it. And I'm fearful that that may happen in this case, because although the professor has mentioned that the current system is somehow elitist, and in Missouri, they don't know who's applying or how it's coming to be. In Kansas, we have an open process, and that any attorney who wants to be on the Court of Appeals or the Supreme Court can apply for that position. And the names of people who have applied is published in the paper. And the commission encourages input from the public as to those particular people who have selected themselves, self-selected to go before the commission and see if they can get through that process. I suppose I'm a good example of someone in Kansas. It's a matter of public record. I'm a lifelong Republican, come from a family of Republicans, and was appointed by a governor who was a Democrat. So I truly felt that when I went through that process, and I know my colleagues have too, that they were never asked what political party they belonged to. They were never asked if they gave money to the governor's campaign. We were never asked any kind of litmus test about how we would rule on specific issues, but were instead subject to an extensive background investigation where our personal and professional friends and enemies were contacted. We were subjected to an interview that is open to the public, so I'm not quite sure. Well, I am certain we don't have any kind of elitism going on here. We have a very open process, whereas if you had the federal model that the professor suggests, then you have a governor that has carte blanche to select whomever he wants. I don't know how open and public that process is. I'm certain it would have to do with your political connections, And I'm certain that we would have people that who would be excellent judges who would never step forward because they simply don't have the political to do that. I had no political whatsoever. I've been a municipal judge and have not been able to become involved in politics. So I think we have an excellent system here. It's served us well. The Kansas appellate courts, the U.S. Chamber of Commerce just came out in 2012 and ranked us 5th in the country among all the courts as far as a business-friendly environment. Ranked us 8th or 9th in judicial competence and neutrality. So we've had a system that has served us well, and I think we should, the voters should be very careful in voting to change that system unless they see there's a problem. Let me mention one other thing. Both the proponents and the opponents of changing the judicial selection system did surveying. Both proponents and opponents. Both surveys came out that a majority of the voters in the state of Kansas do not favor a change to the selection process. As Lynn mentioned, the 10th Circuit Court of Appeals recently, a challenge was made to our process in Kansas, that it was undemocratic. The 10th Circuit Court of Appeals found that our system was democratic. It's not, it is constitutional, it is democratic, and the Supreme Court of the United States elected not to take that case. So the cert was denied just a month or so ago. So that is the law of the land. Our process is constitutional, it's democratic, no one can point to any problems in it, and apparently a majority of the people want to keep the system. So I think what we have to ask, and ask perhaps the proponents here today, is why do we need to change? What is the reason behind the change?
Well, we've had 3 takes. Let's see if we can get to that answer as we go to our 4th take. We're very thrilled to have with us Clayton Barker. Clayton is the Executive Director and General Counsel with the Kansas Republican Party. Prior to joining the state party, by the way, he led political operations for the GOP right here in Johnson County. And I should point out he's also a former partner in the law firm of one of our more prestigious law firms right here in Kansas City, the Spencer Fane Britton Brown law firm. He has extensive expertise in appellate work and electronic discovery. Clayton, where do you come down on this issue?
I am a proponent of reform, but my take's going to be a little different than the professor. And just a little quick background. I mean, I was an Army officer for 10 years, got out of that, went to Katy Law School. I was an attorney for 10 years, left that, and about 3 years ago I just walked into the Johnson County office, and the first week I was moving furniture and cleaning toilets, and then I worked my way up. So politics is kind of new to me. It's not my career, but I've gotten in a position where I get to watch it. And I'm not a lobbyist, I'm not going to run for office, but I've learned the mechanics of elections, commissions. I've learned, hopefully, to sort of look through past labels that we all slap on things. You know, like one label we always hear is the current system is the merit system. Even people that want to change it call it that. And I'll point out, well, whether you want to elect judges or have the governor appoint, the Senate confirm, everybody's looking for merit, just in different ways. And I want to give everyone a quick status of where we are on the legislation, and then I'll just go into my quick beliefs, and then we can get going on the panel. There's 2 sets of legislation going on right now. One is to change the Court of Appeals selection process, and because that's a statute, it can be changed by the legislature on its own. It only takes a majority vote in both houses. And that is House Bill 2019. It's already passed the Senate, and I'm sure it'll pass, or excuse me, it's already passed the House, 73 to 50, and it's going up to the Senate, I believe, tomorrow. They didn't discuss it today. And my sense is it will pass. So the Court of Appeals selection process will change. The other one is a resolution, Senate Resolution, or SCR 1608, which passed the Senate. It needs 2/3, and that may or may not get a vote in the House. Right now, my sense is that the whips tell me they don't have the votes to pass it, but who knows, they can talk to a lot of people and maybe change their minds, maybe not. But I have to remind people that the House and Senate on the Supreme Court selection process are not voting to change the process. They're voting on whether to give it to the people. to vote on whether they change the process. And I've done a little research back in 1958. There were some Republican senators that liked the existing system, but they felt the people should have a vote in it. And so they would make comments like, well, you know, Missouri has the Missouri system, and Pendergast still appointed all the judges, but I'm going to vote for it and give it to the people. And they were kind of surprised in '58 that it came out the way it did. Sometimes people think it was a submarine issue because the big constitutional amendment in that election was the right to work, which was a huge fight. Okay, so that's the status today. Now my, I guess, theoretical take on this, and I'm more going to give you some nuts and bolts, is I believe that appellate and Supreme Court judges, the appellate part of the judiciary, not the trial judges, need two attributes. One is they need experience, ability to analyze, to write, to think. They're not the ones, you know, handling objections and dealing with scheduling orders. And because of that, I personally do not like electing judges. I think that's just a bad idea. And I've had a little bit of experience on that where you know, I was actually not the lawyer in the case, but after we did a real estate deal, the attorney said, now go give the judge a election contribution, because if something happens with this deal, that's the judge that will deal with it. So I don't really like the election side. But on the other hand, I believe appellate judges have a lot more discretion than sometimes people think within the parameters of the law and precedent. And because they have that discretion, they're implementing policy, they can create policy, they can make law, common law. And because of that, they need to be somewhat aligned with the people. And that's why I'm not always fully comfortable with the system we have now. And although it's not a perfect middle ground, I think having the governor appoint and the Senate confirm kind of balances both of those interests. That's my theoretical view, but I'm not a law professor. Now, the nuts and bolts piece where I get in, first of all, some people say this is a power grab by Governor Brownback, and I have to remind them that in the last 42 years of modern Kansas political history, that's when governors started to have 4-year terms, and we had the one-man, one-vote districts. The Democrats have held the governorship 24 years, the Republicans only 18. So the Democrats have done a lot better. So in the long term, you can't really say this is a power grab. And in the 2 years and however many months Governor Brownback's been in office, for 2 of those years, I'd say the Senate was pretty hostile to him. So they're not necessarily a rubber stamp. Right now, they're a little aligned, but who knows what happens in another 2 or I guess 4 years. Now, some of the, when I was a lawyer, I used to get the ballots for the Judicial Nominating Commission. And I always thought it was a kind of an odd system because I never really knew who I was voting for. And I learned when I went over to the Judicial Records Office that I was surprised by how few lawyers in Kansas actually vote for people on the nominating commission. And I think the low end was in 2008, the 3rd district, only 20% of the lawyers voted. And all it takes is you get a ballot in the mail, you check your name, and you mail it in. And the high end was the 1st district in 2010 with 42%. The last statewide one, and I guess we're re-electing the statewide chair this year, was 30%. And that kind of caught me by surprise because lawyers are supposed to be a very interested group of experts that would pay a lot of attention to this. And I went over and asked if we could figure out who had actually voted in these elections. And the clerk of the court said they don't keep a record of that. You know, on every other election, I can figure out who voted and do demographic analysis, age, men, women. But I can't do that with the lawyers to figure out whether it's a big firm, small firms, certain towns. If you're out west, is it like the hometown guy gets all the local lawyers to vote? Plaintiff's defense, appellate trial, I just don't know. I can hypothesize why certain lawyers would not vote. I think it's because defense lawyers, or excuse me, not defense, business lawyers feel they don't know enough about trial or appellate work that they shouldn't vote. And then even talking to the lawyers that voted, there's a vacuum of information on who they're voting for. They tend to vote, we'll get a letter saying, I'm running for office and here are 30 people that have endorsed me. Or maybe I'll just get a letter, not from the candidate, saying, we think this person should be on the board, he's a great person, go ahead and vote for him. If you call the office, they all say about the same thing. I did do a little investigating the last time. And so I got the feeling, and I've asked a lot of lawyer friends, is they don't really know who they're voting for. They tend to do it off a recommendation from somebody. concerned me because the guy that does elections, that would be the easiest kind of election to gain if you wanted to. Small number of people turning out, you know exactly who they are by name. You would never be a partisan in your face, you know, these postcards you get in a regular election. You would be a soft sell. You would find someone who would call a friend at a firm and encourage people in the firm to vote for other people. And especially with the large firms in Kansas City, if a senior partner were to say, I'd recommend you vote for this guy, he's my friend, he's a good person, go ahead and do it. And I've gotten emails like that when I was at Spencer Fane. A lot of lawyers may go ahead and vote that way. It's been a big change in the bar since 1958. In my old firm, they went to 12 people in 1960. That was considered huge, double digits, lawyers in a firm. So that's my concern there about the system. And I did a little more research, and I'm almost done here. In 2011, in the 2nd District, it started out with 4 lawyers running, and they had to do a second vote. It was Natalie Haig, who had been Bill Gates' lawyer, had served in the Kansas Chamber, and a gentleman named Fred Spigarelli, who was the head of the Kansas Trial Lawyers, or maybe not head, but involved with them a lot. Both were fairly large donors to politics. I wouldn't call it a partisan election. There was a clear divide there. And though I wasn't involved in it, I was told that there were groups on each side running campaigns for each of them. And in the end, Natalie won. And then my last point, why I also think this is a concern to me, is there isn't a lot of media attention on this. The media never paying attention to who gets on this board. Who's ever on the board controls who becomes a judge. Does anyone here I'm just taking a quick poll. I didn't know this until today myself. What happened in the 3rd District election this last time? This was kind of, I think they made exactly the right call on this, but it's kind of surprising. They started out with 4 lawyers that were running for the position on the nominating board. Nobody got a majority, so they took the top 2. Right before the ballots went out, the redistricting decision came down. I think you all remember that. One of the lawyers was now in the wrong district. They had 1 left. They also just lost a lot of lawyers in Douglas County, gained probably, I'm going to guess, a handful in Miami, and the only choice was they had to go with the incumbent, Matt Keenan, who's a great lawyer. And they made the right decision. I'm not questioning that at all. But the fact is it never made the news. Nobody knows what's going on. That's another reason I get concerned as sort of, I guess you'd call me a political operative, amateur, that when something is not in the news, it's this important to the state, and there's that low level of participation, it just concerns me. And I can't point to any bad judges or anything else.
You make some great points and new ones to the conversation. So let's get a response, though, to those ones. Let's start the conversation. And I did see another comment, because these were on Facebook too, some of the things you talk about. Changing our judicial selection process from an archaic board of insiders, mostly selected by a disinterested body of lawyers, the numbers who bother themselves to vote rarely exceed a third. So, who wants to address that? We have Judge Alderberger.
I want to address kind of a collateral issue. I think it's very interesting that there's a concern on the part of the proponents of changing the system that only a small percentage of lawyers vote for the lawyers on the commission. Therefore, because such a small, we certainly would like to see many, many more lawyers vote. Yet, I think it's also very interesting that the constitutional amendment that is before the Senate right now was argued on the Senate, that constitutional amendment to change the selection process currently reads that the election will be during the primary in August of 2014. When in 2012, 23% of the voters voted in the primary compared to 67%, I think, in the general. On the floor of the Senate, Senator King was asked about that. Well, certainly, if you agree in democracy, don't you want to have this election during a general election instead of the primary? And the answer was no, we want to get this to the people as soon as possible. So I think it's interesting that the proponents are concerned about the percentage of people on the that vote for attorneys on the nominating commission, but they certainly want this very important constitutional amendment to be in a primary election when less than a third of the people that vote in the general election vote.
Let's get Lynn Johnson's reaction to this too.
Well, I have the same reaction. And
he's standing up with it.
well, I don't like to sit down. When I'm in court, I have to stand up when I'm speaking, and so it's just, there's a little something odd when the proponents want to rush this constitutional amendment, which they're not going to have enough votes to get out anyway, but if they did, they want to do it in the primary. Who votes in the primary in Kansas? The people that voted out 12 of very, very good moderate Republican senators that this administration decided that they were going to get rid of. The people that vote in the primary are the people that voted out 12, think about it, 12 great maybe, but very, very good moderate Senate Republicans. Why? This is one of the reasons why. I've talked to them. I know these Republican senators. Governor Brownback has told them, at least two of them that I know of, we are going to make sure that we are able to appoint judges that we want to appoint. And because the chairman of the Senate Judiciary Committee from Johnson County refused to let that happen, he was defeated, along with 11 of his co-moderate Republicans. This is nothing more than a power grab, period, exclamation point. There's no way around it. And when Clayton says, I didn't even know who I was voting for. Well, find out who you're voting for. Do some research on the lawyers that are running. Make sure you know who they are. I mean, how can you stand here and say, this is a bad system because I didn't know who I was voting for? You know, the other issue that Clayton brings up is the judicial branch should be aligned with the people, I think. Well, the judicial branch of government is an independent third branch of our government. Executive, legislative, judicial. Why is it an independent branch of government? Because it's going to make decisions that aren't popular. It's going to make decisions based upon the Constitution and based upon the rule of law that isn't popular with everybody. It's going to protect the minority against the will of the majority, which is the legislative process. That's why we have an independent judiciary. Go back and look it up from England on through today. And if we want, as the professor says, we want more legislative involvement, we don't want legislative involvement in the courts. That's the whole point. We don't want the executive branch involved any more than it has to be. That's why, let me just, one more point. That's why 2/3 of the House and 2/3 of the Senate in 1958 said, we're going to establish, quote, a non-partisan nominating commission. Non-partisan. And it went on to set out how it would be derived. One lawyer elected by all the lawyers in the state as chair, and then one lawyer from each congressional district, and one lay person. This wasn't something the lawyers dreamed up or the Kansas Bar Association dreamed up. This was the legislature in 1958 making the decision, 2/3 of the House and 2/3 of the Senate, that we want a commission that's nonpartisan, and here's how it's going to be made up. It's going to be made up just like it is today. This isn't something, again, the Kansas Bar Association decided, and 60% plus of the people voted for it. So, and I would challenge the professor to find anyone. I've got the list here of every 3 nominees since 1964 to the Supreme Court and the Court of Appeals. I've got them. And I would challenge him to go through those and find someone that's a lackey or someone like you described was sent to the governor of Missouri. I'm not talking about Missouri, I'm talking about Kansas.
Well,
And you're not going to find anyone, you're not going to find someone that isn't qualified amongst every one of those three. And Judge Arnold Berger is a perfect example. Republican, appointed by a Democrat. And when I was on the chair, or when I was chair, you know, we didn't know who we were sending. You can believe that or not believe it. And other people here can believe it or not believe it. But it's the absolute truth. And we sent 3 people to Democrats and to Republican governors. So there's more I could say, but I'll sit down.
You know, what was it that Professor Eckhart said in his opening statement? What some of the words he used? There was the concern about attorneys becoming clubby. Yes, wasn't that the word? Full of special interests and elitist. I like the way that Clayton and I appreciated him doing it, outlining the proposals that were occurring in Topeka. He outlined the different proposals. Another proposal came forward in January from the Kansas Bar Association, acknowledging that there were concerns about public sentiment and how the legislature was going, and they proposed expanding the nominating commission from 9 members to 15 to allow more members of the public, non-attorneys, to be part of that.
More politics involved.
15 people, but this was the Kansas Bar Association.
I don't agree
The Kansas
with
Bar Association themselves, so you'd have only 4 attorneys, and the rest would come from members of the public. They would be appointed by the governor and the legislature. This was the Kansas Bar Association proposing this. So rather than do a constitutional amendment, rather than go through a voting process, just expand the nominating commission. Is that a sort of halfway house way of handling this deal? That we don't have to go through a constitutional amendment, a way of getting the public far more involved in this process? Would you support that, Clayton?
Personally, I think that would be an improvement on what we
Let's
have.
get the microphone over there. I'm sorry.
I think that would be an improvement on what we have now.
Because attorneys would play less of a role, the public would be...
Yes, it would incrementally improve it because we have fewer people elected by just the lawyers, but I'd also be concerned about the governor having the ability to appoint 5 people on a board. Then the power's all of the governor and there's no check on it. Not that I think any governor would appoint a bunch of brainless lackeys that would just do something, but... And I did want to respond to at one point, and I did check up on who I was voting for. I just think the majority of lawyers don't have the time to follow up, and they just throw the ballot in the trash. And just one more quick follow-up on the turnout for the primaries. I know this is a statistics game, but if you take out the unaffiliateds who don't vote in a Democrat or Republican primary, and take out the voters that don't have a contested primary, the number actually goes above 50. People do turn out if there's a fight. If there's no fight, they just stay home. And I know we can play with numbers all day, but
what is the reason for not putting it on a general election? Doesn't that seem to make the most sense? I don't understand the rationale.
that I don't know. We probably have to ask Senator King. And I understand your point that you think that who's ever putting this forward will think in the primary they'll get a better, what would you call it, slice of the voting public to vote for it.
Okay. Professor Eckhart.
We have experience with what one did with commissions. You can have lawyers appointed by different majority leaders in the legislature. You can have them, there are all sorts of ways to get lawyers on there that are taken outside of a semi-private organization, which is, of course, the real complaint and accountability. So there are a whole series of things that one can creatively do. I think the issue may be beyond that, though, with bills and voting and going. But, to find, it's very difficult to argue this particular position, my position, because you're not going after a judge. You don't want to go after a judge, and I'm not going to go after an opinion because my task as an officer of the court is to respect them. But let's be fair to my side. How are you supposed to prove the negative? You say, show me one. Well, I think in my, when I went through 2007 and 2008, I at least showed the potential for somebody who could have been much, 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 much better. Now, that's not denigrate the poor people that were involved in the process and are selected. That's just happened. But there are lots of different ways to do specific things. But the main issue is accountability. That's the issue. Politics, of course you're going to have politics. Haven't you heard enough bar politics and politics in this? Don't we have elections about politics? Isn't that the whole process? I mean, national elections all the way down. That's what each candidate comes saying, I'm going to appoint my type of judge. Well, that's not all bad, but you want merit, and presumably, because you're accountable, if you appoint someone who does something impermissible, or so, you can be politically accountable if you have some sort of control over it. At least in Missouri, no branch of government has control over it. That's the problem.
You know, the federal government allows for the Senate to confer. The president picks somebody he wants, and the Senate confirms it. It is a simple process the public fully understands and embraces at the national level. They fully understand that system.
The Bar Association passes on them. Does it not?
Yep.
It powerfully passes on them.
And the Senate
Why
filibusters.
why is that not adequate for the Kansas system?
Because right now we see the Senate is filibustering very good appointees by Obama. And the same thing has occurred with Republicans, but much more this way. So why are we trying to make it more political? This is, if you have a, I don't really like I don't like the federal system at all. You know, in my opinion, there should be, at least for the circuit courts and the U.S. district courts, there should be a similar type of commission. But at least on the federal level, the president normally isn't the best buddy of who he or she is appointing to all of the U.S. district court trial benches or to the courts of appeals or to the Supreme Court. Whereas in a small state like Kansas, that's who's going to be appointed by the governor. And to say that our Senate, which is, 8 Democrats? So our Senate is going to not approve somebody that Governor Brownback appoints? Or let's put it another way. Let's say that we somehow miraculously have a Democratic governor, and you still have only 8 Democrats in the Senate. Do you think anyone who a Democrat governor appoints is going to get through this Senate, made up primarily of right-wing Republicans who replace these 12 moderates? Of course not. So, you know, that is not a model. And I keep coming back to, the professor just said, accountability. There has to be accountability. Accountability to who? Accountability to who? To the legislative branch? To the executive branch? No. It's an independent third branch of government accountable to the rule of law and our Constitution, which is what separates us from other countries, the rule of law. Now, if you want that to be trampled over by elections like in Texas and Ohio and other places where huge multi-million dollars are raised for their Court of Appeals and Supreme Court justices, or if you want the governor, be he or she a Democrat or a Republican, being able to, like Kathleen Sebelius, a good friend of mine, she could have just appointed me. You know, why not? She could appoint anybody. Just like Brownback can appoint anybody. There's no merit. There's no nonpartisan. So either, and this elitist stuff, I mean, I don't even know where to start with that. That's like saying the doctors that decide who should have licenses are elitist because of who they allow to be doctors. I mean, it's, sure, maybe we should have more on the commission. Maybe 1 more, maybe 2, 3 more. You know, that's something that could happen. You could have the governor appoint a co-chair, so then you have the same number. But when you start fooling around like the KBA is with having the minority leader in the House gets an appointment, the majority leader in the House gets an appointment, the minority leader in the Senate gets an appointment, the majority leader in the Senate gets an appointment, the governor gets another appointment. And what I thought was great here, someone just said, and who knows, the governor may appoint some lackey. Whoa, wait a minute. If he appoints or she appoints a lackey to the commission, that's what this bill 2019, which has passed the House and is going to the Senate and will pass there, that's what Governor Brownback and every governor thereafter will have the ability to do, to appoint whoever they want, with the Senate approving. And if it's a Republican with this Senate, it's going to be approved. If it's a Democrat, it's not going to be approved. So, you know, yeah, it's almost laughable to me in many ways. And again, Professor, I'm not talking about Missouri. I mean, I understand that there may be some issues in Missouri. But no one has done a study that shows that any of the 3 people that have been sent to any governor since 1964, you know, is a bum or, you know, stupid or, you know, shouldn't be there, or that any commission would send 2 Democrats and, you know, 1 lousy Republican to Kathleen Sebelius, or 2 Republicans and 1 lousy Democrat to Governor Brownback. No one has pointed that out because it doesn't occur. I mean, you know, somebody said, I can't prove a negative. Well, that's the point. You know what we're here about? We're here because the Kansas Supreme Court is the only entity fighting for the school systems in this state. It's the only branch of government that's working for the school system. It's the only branch of government based on our Constitution that's requiring the legislative branch and the executive branch, those wonderful branches that should be, you know, appointing the members of the court, accountable. That's why we're here. I don't remember the names of the cases, but there's a case 3 or 4 years ago. Yes, Montoy. We wouldn't be here if it weren't for Montoy. But that's why this is so important, to maintain an independent judiciary.
Is it about that, Clayton?
He's going to say no.
Well, let's just get the answer. Because I have an answer to that, too.
I would say that Montoy was probably the spark that started this, because this movement started when Kathleen Sebelius was still governor. And there's a lot of lawyers and judges, and I actually had the privilege once of driving Justice Scalia around, and he was mocking the state for that decision, that suitable should not be translated into a formula and dollar amount, that the court should not have as its client the school system. And that in and I've read when the amendment was put in to put that language in the Constitution, they didn't see it as a dollar amount. They saw it as predictable funding from the state was the problem they were trying to address. And that's one of those issues of discretion. Those words can have a lot of meaning, and the court has wide discretion on how it interprets it.
But to me, then it would take an awful long time to change the Kansas Supreme Court if it was about that issue. And just like on the federal level, would you not have, you would have no control over what that person was going to do once they were on the bench. Isn't that the case? Can you bring the microphone back over here?
One other quick point.
Well, you had your chance. Then, I mean, isn't that like that at the federal level? You think you're getting someone. Sam Brownback says, okay, it's about schools and I want this person. And I really think it's going to be this, and they're completely different. So for all of the concern over this issue, we have no control over who's going to be on that court and how they're going to rule once they're on that bench.
What if we continue with the Supreme Court Nominating Commission and there's a vacancy and there are 3 qualified attorneys and or judges that are submitted to Governor Brownback? We don't know how they're going to vote necessarily, but it's not going to be a political decision by Governor Brownback. You can rest assured it's in their genes, whether it's Governor Sebelius, Governor Parkinson, Governor Brownback, or whoever it is. If they're given that authority, they are going to appoint people that they believe and probably have asked and probably have answers will make decisions the way they want them made. Sure, it will take some period of time. Does that make it right? Does it make it right that it might be 20 years from now before the court is packed the way whoever has been in power wants it packed? I mean, it doesn't make it right. The point is, what's right and what's wrong? A nonpartisan methodology is what's right. Handing it all over to the governor like 2019 does. I wonder, Judge Arnoldberger, do you think you would have ever made it?
Never.
There's your answer. You ask any member of the Court of Appeals, and most of them will say, I'm not a political person. I didn't get involved in politics.
Okay, let's bring this back. But you indicated you were a lifelong Republican. You could have made it.
Well, no, because I wasn't involved. I was a municipal court judge. I couldn't become involved in politics. Before that, I was an assistant U.S. attorney at the federal level. I couldn't get involved in politics based on my job, so it would just have been nothing I would have pursued. And that's one of the wonderful things about our current process, is that any attorney in Kansas who wants to pursue a judicial career has the ability to put their name forward and be seriously considered. Now, they may not make it, they may go before several governors, they may never make the final three, but they can all be seriously considered, and it has nothing to do with your politics or how much you contributed to the governor's campaign.
Thank you. Clayton, I did interrupt you earlier. I mean, you get it all back now.
Oh, just a short point, that there aren't, unlike the federal system where we actually do the district judges too, there aren't that many judge slots in Kansas. They're not all going to change at once. And if you think of the governors we've had, it flip-flops back and forth. No party has held the governorship past a current governor. Some have gotten reelected, some haven't, but it flip-flops. So I don't see it as one party they're building a dynasty of judges by filling every slot over time. It's not if there's some takeover going on. And I don't remember. Are there any empty judge slots right now? Appellate court or
No, there were just two
filled, right?
If you have questions, I will also take those, okay, if you bring your cards over. Let me ask you this question. We also have, and the public gets frustrated with this, we have an opportunity to vote on the retention of judges. And has anyone ever not been retained on the Kansas Court of Appeals or on the Supreme Court?
No, they haven't, and I think that's probably an indication that they've been very good selections.
So that in your mind is a positive thing?
Another thing I want to point out about that is, actually, I believe it was the impetus were the attorneys in Kansas that were concerned that voters would say, look, I don't know anything about these judges that are up for retention. How can I make a concerned choice if I don't know anything about them? And so the attorneys in Kansas pushed for and got a judicial performance commission that would send out surveys to people that appeared before judges both at the district court level and the Court of Appeals level and the Supreme Court level, where people were allowed to judge us and rank us, and jurors would rank us, and district judges would also be judged by appellate judges, and appellate judges by district judges. There was a wide cross-section of people that would be surveyed. And then those survey results would be on the website, the Supreme Court website. So you could see any judge up for retention vote, you could see how they came out in the surveys and whether it was recommended that they be retained or not. One of the first actions of this administration was to cease funding of that program. So we no longer have the judicial performance evaluations being done or out there for the public to see because it was defunded.
Okay. And actually, because this is one of the questions we have from our audience, I mean, is not the opportunity to vote on retention of judges a form of accountability, Professor Eckhart?
It certainly is that no judge has been not retained. And the issue becomes, again, accountability. If you've got to go have a real retention issue, somebody's really misbehaved in the bench. Do you want that done in an election, or you want it done in a well-run judiciary committee, usually in the Senate? I think you don't want it on the stump. But the other thing, this is one of my real concerns, because 60 to 65% are what usually vote for retention. 35% of all voters just roll off retention. This scares me to death, because whether it's the Iowa situation or others, this is the way you get in trouble. And which, at least in Missouri, in our reform, one of the things that causes me real fear, because if you have a decision that it goes contrary, school funding, if dare I say, and you start having judges rolled off the court, then that's the fear, and that's what you don't want.
I'd like to respond to that too, is I think most judges, they're big. I think there's not a fear of necessarily the retention process unless there is a decision like in Iowa where there's a concerted effort to oust someone because of a decision made. Most judges fear the Judicial Qualifications Commission, and if you do something unethical, you're going to be removed from office. And the cases throughout Kansas that I have known over the years of unethical judges, it hasn't gotten to a point to them to go before a retention vote to be removed because they've been removed by the Judicial Qualifications Commission long before that. So that's our fear as judges is to not be removed by the Judicial Qualification Commission, which I assure you is going to act much faster than any voting populace could act.
Questions from our audience. Why does Clayton think a governor is more able to select competent judges than the commission?
It's not so much a matter of competence. I don't think that I know of any incompetent judges. It gets back to that discretion that the appellate judges have, and that a governor, having been elected by the people, will be more in tune with that philosophy, and then having the Senate confirm it, make sure that the judge and their ability to use their discretion is more in line with the political philosophy of the people. Because it's not a matter of independence. Independence is really your job security that allows a judge to make decisions. And I've read a lot of Kansas political history. Elected judges who had to face the voters made some heroic decisions in Kansas history, desegregation cases and others. So the method you came in doesn't necessarily mean you're lacking independence. And again, I don't think it's a matter of technical competence. We all like to use the word merit. It's hard to define. What is merit in a judge? We can talk about it in big words, but when you get down to it, it's hard to know what are you going to score on a 1 to 10 scale. This judge is 9, this is 8.8. So I really think it gets to that discretion and making sure the judge is somewhat aligned with the basic philosophy of the people in the state. That's my feeling.
I ask you to keep the microphone there for a second, because you've just mentioned it briefly here in your answer, because another question here from our audience. If the selection process changes, would a decision like Brown versus the Board of Education ever be possible?
I think it would be. I just finished doing a lot of reading on, because February was Black History Month, and this is Women's History Month, sort of history. And there were some decisions made by judges on, again, desegregation in Kansas, in Coffeyville and Merriam, where the public was outraged, and these were elected judges. They had to turn around and face the voters, and they stood and said those schools will be desegregated because they weren't cities of the first class, or it was elementary or not elementary. So I think that's perfectly possible.
Anyone else? No, Judge, you passing on that
No,
one?
pass it on.
Professor Eckhart.
I think again, the issue is accountability.
That's your favorite word today.
It sure is.
Okay, all right.
Because it's political legitimacy. That's what we're talking about. And if you don't have political legitimacy, you're in trouble.
Well, I'm really not answering the question, but I want to go back to something that Judge Arnoldberger mentioned, and that's the Kansas Commission on Judicial Performance, which was established as a result of the Kansas Bar Association and attorneys pushing it through the legislature, because too many people would say, I don't know anything about this judge. I don't know anything about this justice. What do I do? And so they established the Kansas Commission on Judicial Performance, and it did a very good job while it was in existence. For example, this is how thick the evaluation form is for one of our members of the Court of Appeals. So the same party that Clayton represents, who says they want merit, decided to defund it, as Judge Arnold Berger just pointed out. Why, if you're really concerned about the quality of the members of the Supreme Court and the members of the Court of Appeals, why would you defund this? I guess so you can cut down the income taxes, I suppose, or something. But you know, why would you defund this if you really were concerned about it? So this is a real sticks in my craw, really deeply, because you know, it's not what you say, it's what you do. And also the point that Clayton has made a couple times about this discretion, the discretion to be like the people. Wait a minute, we're having a governor appoint his or her person who has the discretion to do what that governor wants to do. And I can tell you, and you can again believe this or not, but when Kathleen Sebelius was governor, or when we've had prior Democratic governors, if they would have been proposing this, I would have been up here fighting just as hard as I'm fighting now. It has nothing to do with being a Democrat or a Republican. Unfortunately, it does now, but it shouldn't. If we had those 12 brave, moderate Republican senators in the Senate, we wouldn't be here having this discussion. Because this so-called reform, always be leery of anything that's called reform, but this so-called reform would not be going anyplace. And we would continue to have good, I love it. Judge Arnold Berger said, you know, it's a good thing that our judges are being retained. The other says, well, it's a bad thing our judges are being retained. So, you know, it's like they wished there were some bad judges that hadn't been retained so they could say, look at this judge. And by the way,
You'd think there'd be 1 in 70 years, though, that might not meet the standard, wouldn't you?
actually, no, Professor, I don't.
Not
it's
1
not
in 70 years over the states?
No.
Oh, come on.
We're only talking about the Supreme Court and the Court of Appeals.
Well, I'm talking about retention all the way across the United States.
Well, anyway, you know, so that's...
I'm going to get some final thoughts from each of our panelists, and we're going to start with Clayton, our executive director of the Kansas Republican Party, getting a sense at this point, because I've offered, and you offered two at the beginning, I offered a third, as to how this is going to play out in your judgment and your political chops that you bring to the table here. We've got the constitutional amendment that could be on the ballot at a very convenient time for voters in August of 2014. We also have the potential for just a straight legislative vote on just the Court of Appeals. And then we've got the expansion of the nominating committee that will have more of just the public being involved. Will we see any change of any kind after all of this conversation and all of the, I said, all of the discussions that have occurred here? What do you see happening as a result of this legislative session?
Okay, first of all, remember, retention is different than nominating, getting in versus keeping. And my personal preference on that, though that's not in front of the legislature, is just get rid of the retention process. I think the judge is right. If a judge has a problem, they'll be taken out. It shouldn't be up to the voters because nobody knows enough. Someone will be impeached or in a felony or something before the voters will take them out. But from what I expect to happen, I believe the Court of Appeals will go to this new system where the governor appoints and the Senate confirms. I think both houses, there's a pretty easy majority in both houses, and the governor will sign it. And the governor said that's all he wants. He said he would take the Supreme Court if it was given to him, but he didn't ask for it. I am not sure if the amendment we put in front of the people, again, the Senate's voted for it, the House is, I think, 10 votes short right now. And if the whips don't think they have the votes, my sense is they won't even put it to the House for a vote. They might, that's not my, I'm not involved with that calculus at all. I just hear about it secondhand or see it on Twitter or something. And on the commission, my assumption is that will pass. I'm really not as familiar with that one as the Court of Appeals law and the resolution.
I'm interested to know about you, Judge, as a Court of Appeals judge. If that bill does indeed pass, because that would be much easier, it's just a legislative vote, Court of Appeals, do you find yourself out of a job if that were to happen?
No, I don't find myself out of job. The bill as it currently says, I mean, I was just retained for 4 more years. All those on the court will continue through the retention process every 4 years. So it doesn't affect
You are a lifetime appointment.
as long as I'm retained
Okay,
until
all right.
I'm 75.
Yes.
The thing that concerns me is, as we've discussed today, we have a system that's not broken. We have a nonpartisan selection system that has served this state well, that our parents were brilliant in putting into place. We point a lot to the fact that, oh, we want the federal system, or oh, Kansas is the only state that does it this way. Well, I'm very proud of my Kansas heritage, and I think we got it right. And I think we need to take credit for having gotten it right. And the thing that concerns me is, there's nothing broken. The people of the state of Kansas seem to, at least through surveying, not want a change to the selection process in Kansas. But it's going to happen because, in all honesty, because the governor has willed it to happen. And regardless of what the people of this state think, it's going to happen. And that to me, besides the fact that I'm a judge, that to me as a Kansan is very disturbing. And
Professor Eckert, you are a big picture person because you don't have to be on the fence. You can just listen to this conversation and be the grand person with the law looking at the bigger picture. But, you know, people get a lot of bent out of shape here looking at a shifting, a tinkering, a modifying. Some people think a huge crisis in a change of a system here. I mean, what's the worst that can happen with this change, do you think?
Well, when I came here, as some old trial lawyers would say, I don't have a dog in this fight, so it might be inappropriate for me to comment on what Kansas ought to do. I think it's commenting on Missouri, I think a 70-year-old law needs to be modified and changed. And I would suspect that there are ways, just because you have a system doesn't mean you can't improve it. If you don't improve it and it stagnates, you got a problem. And there are ways that I suggested, and I hope we don't go to elections. And I am reluctant even to go to the federal system. But that's where I stand, and that's what's going on. And I'm afraid that we are going that way. We're going all the way to elections. And I think this is sad because everywhere I go, the old professor in me thinks that this ought to be a discussion without emotion on constitutional merit, and it isn't that way any place. It amazes me, but I think that's tragic.
Can I sum up your comments this way in one word as accountability, Professor Eckert?
I say that from a constitutional point of view. I believe in the people. I believe in the people I elect. I believe in the presumption of regularity, whether it be my legislator or my governor. And yes.
Thank you very much.
That's what constitutional law is about, accountability.
The final word goes to you, Lynn Johnson. Do not abuse it.
I will try not to. Like Judge Arnoldberger, I grew up on a farm out in western Kansas and came to Kansas City, Johnson County, a number of years ago after graduating from Washburn Law School, never envisioning being involved in anything like this, but being someone who really felt strongly about sort of the Kansas values. And I agree with Judge Arnoldberger that part of the Kansas values is making sure that everyone has a fair opportunity and everyone has a fair shot and everyone is protected by a strong independent judiciary. Most people in Kansas may not say it quite that way, but that's what is protecting them. And if we go to a system where the governor can appoint whoever he wants to appoint, I made a little joke a little bit ago about how Kathleen Sebelius could have appointed me as to the Supreme Court, and because we're good friends, and my wife's a good friend of hers, and I would have been in that little elite circle of her friends that she would have considered it if at that point in time that's how it would be done. So you talk about elitism. I know who would probably be on the Supreme Court right now if Kathleen Sebelius was appointing in place of Eric Rosen, Lee Johnson, Dan Biles, and probably one other one. You know, these are people who were appointed to the Supreme Court by Kathleen Sebelius to the nominating commission. And I'll just use Lee Johnson as an example. I'll just use Lee. I'm sure none of you know Lee Johnson. Lee Johnson is a small town lawyer from, and I can't remember. Caldwell, Kansas. That's another thing. People say, oh, there's too many justices from Johnson County and Wyandotte County, and there's nobody from out. He's from Caldwell. And he first came to my attention when I was chair of the commission. When he, and again, I go back to, instead of the small group of people that Kathleen knew, or that Bill knew, or Mark Parkinson knew, every lawyer and judge in this state has the opportunity, and we have the opportunity to benefit from that by every lawyer in the state being considered. Lee Johnson would never, ever, ever, ever have been appointed by Kathleen Sebelius or Bill Graves or Governor Brownback, because he is the anti-political person. He came before the Supreme Court Nominating Commission because he wanted to be on the Court of Appeals initially. And I'm going, who is this guy? He had, at Washburn Law School, I think he had like 15 top papers. Top papers meaning that you got the best grade of everybody in that particular class. Very, very, very bright, smart, quiet, articulate person. He'd been an insurance salesman before he went to law school. Continued to be an insurance salesman afterwards because he couldn't make enough money necessarily practicing law out in Caldwell. So he did both. He was an insurance salesman and a lawyer. We were so impressed with him. We meaning every lay person on, I still don't know whether Lee's a Republican or a Democrat. I have no idea to this day. But I know we were all blown away by him. And he ended up making a panel, being appointed, I'm not sure whether it was by Bill, I think it was Bill Graves, perhaps. I could look back here and find out whether it was Bill Graves. Yes, Governor Graves, Republican, appointed him. And the people that he was competing against, Steve Hill, who's now on the Court of Appeals, and Lawton Nuss, who's now the Chief Justice. I don't think any of those guys were bad. So he was appointed by Governor Graves in 2000 to the Court of Appeals, and then appointed by Governor Sebelius to the Supreme Court in January of 2007. He would never have been in the inner circle of Bill Graves. He was not in the inner circle of Kathleen Sebelius. He's not in the inner circle of Mark Parkinson, and not in the inner circle of Governor Brownback. You talk about something being open and above board and not elitist. This system is exactly that. As Justice Six says, or no, the judge who wrote the opinion that held this to be constitutional said, really what the commission does is non-governmental. It's kind of anti-government in that, it's something that's being done for the betterment of the people, but not through the normal legislative or executive branches. So let's don't talk about elitism, because instead of Lee Johnson, it might be me on the Supreme Court, or one of Kathleen's other friends. I'm serious. That's exactly what happens. Kathleen would say, Who do you think, Lynn? Who do you think, Gary? Who do you think? Who do you think we ought to do? And it would be somebody from that small circle. It wouldn't be Lee Johnson. So that's my closing. Lee Johnson he's not related to me. He is a powerhouse, bright, articulate, someone you all should be proud of to have on the Court of Appeals and now on the Supreme Court. That's it.
Lynn, thank you very much. You know, when you go on an airline these days, you hear that announcement when you're landing and you're at the airport, and they say, "We know there are many airlines in which you can travel. We thank you for flying with us." We thank Lynn Johnson, Professor Bill Eckhart, Judge Karen Arnold-Berger, and Clayton Barker for being with us on this panel. And we thank you for investing of your time, and our audience at home for watching too. Thanks to the League of Women Voters for compiling this whole program. Thanks for spending part of your Monday with us.